All right, ladies and gentlemen, thank you so much for your patience. As you can see, there are other people in the courtroom today. It's unrelated to this case. Each party is going to have a chance to do their closing arguments to you. I'm going to read you the jury charge, or what's called the charge of the court. You do not have to memorize it. You will have the original with you when you begin your deliberations. Charge of the court. Members of the jury. The defendant, Mariano Rendon, stands charged by indictment with the offense of aggravated assault alleged to have been committed on or about the 20th day of August 2023 in Bexar County, Texas. To this charge, the defendant has pleaded not guilty. 1. Our law provides that a person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of aggravated assault if the person intentionally, knowingly, or recklessly causes serious bodily injury to another. 2. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 3. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of but consciously disregards the substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 4. Justification defense of self-defense in defense of a third person. Self-defense. You are instructed that it is a defense to this prosecution if the conduct of the defendant was justified by law. A person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. A person is justified in using deadly force against another, 1, if the person would be justified in using force against the other in the first place, as set out above, and 2, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. The use of force against another is not justified in response to verbal provocation alone. Reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition, including a death. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person, 1, who has a right to be present at the location where the deadly force is used, and 2, who has not provoked the person against whom the deadly force is used, and 3, who is not engaged in criminal activity at the time deadly force is used, is not required to retreat before using deadly force. If all 3 of these factors are met, then in determining whether such actor reasonably believed that the use of force was necessary, a finder of fact may not consider whether the actor failed to retreat. A person has a right to defend from apparent danger the same extent as he would had the danger been real, provided he acted upon a reasonable apprehension of danger as it appeared to him from his standpoint at the time. When a person believes, as viewed from his standpoint, that he is in danger of an unlawful attack or a threatened attack at the hands of more than one assailant, he has a right to defend himself as instructed herein against either or all of them. You are instructed that the defendant's belief that the deadly force was immediately necessary is presumed to be reasonable if the defendant, one, knew or had reason to believe that the person against whom deadly force was used was committing or attempting to commit the offense of robbery. Two, the defendant did not provoke the person against whom the force was used, or if he has, the actor abandoned the encounter. And three, the defendant was not otherwise engaged in criminal activity other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic at the time the force was used. The presumption of reasonable belief applies unless the state proves beyond a reasonable doubt that the facts giving rise to the presumption do not exist. If the state fails to prove beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the jury must find that the presumed facts exist. If the jury has a reasonable doubt as to whether the facts giving rise to the presumption do not exist, the presumption applies and the jury must consider the presumed fact to exist. Even if the jury finds that the state has proven beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the state must prove beyond a reasonable doubt each of the elements of the offense charged in the indictment as instructed in this charge. A person commits the offense of robbery if, in the course of committing theft of property and with intent to obtain or maintain control of the property, he intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of theft if he unlawfully appropriates property with the intent to deprive the owner of property. In the course of committing theft means conduct that occurs in an attempt to commit, during the commission, or in the immediate flight, or after the attempt or commission of theft. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to effect the commission of the offense intended. Appropriation and appropriate mean to acquire or otherwise exercise control over property other than real property. Appropriation of property is unlawful if it is without the owner's effective consent. Property means tangible or intangible personal property or documents, including money that represents or embodies anything of value. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether express or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by deception or coercion. Owner means a person who has title to the property, possession of the property, or a greater right to possession of the property than the person charged. Defense of a third person. A person is justified in using deadly force against another to protect the third person if, one, under the circumstances as he reasonably believes them to be, the actor will be justified under the law of self-defense as instructed above and using deadly force to protect himself against the unlawful deadly force he reasonably believes to be threatening the third person he seeks to protect. And two, the actor reasonably believes that his intervention is immediately necessary to protect the third person. The defendant is not required to prove self-defense, and the defendant is not required to prove defense of a third person. The state must prove beyond a reasonable doubt that the defendant did not act in self-defense and that the defendant did not act in defense of a third person. 5. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 20th day of August 2023 in Bexar County, Texas, the defendant, Mariano D. Rendon, did intentionally, knowingly, or recklessly cause serious bodily injury to Pablo Rodriguez Salazar by striking Pablo Rodriguez Salazar with Mariano D. Rendon's hand or striking or pushing Pablo Rodriguez Salazar with Mario D. Rendon's knee, then you will next determine whether the defendant acted in self-defense or in defense of a third person and proceed to paragraph 6. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty and do not consider paragraph 6. 6. Now, keeping in mind the instructions regarding self-defense in defense of a third person given in paragraph 4, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Mariano D. Rendon, committed the charged offense of aggravated assault, you must decide whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense and whether the state has proven beyond a reasonable doubt that the defendant did not act in defense of third person. Self-defense application. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, Mariano D. Rendon, committed the offense of aggravated assault as charged in the indictment, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 1, Mariano D. Rendon reasonably believed, as viewed from his standpoint, or is presumed to have reasonably believed, that Pablo Rodriguez Salazar was using or attempting to use unlawful deadly force against Mariano D. Rendon, and 2, Mariano D. Rendon reasonably believed, as viewed from his standpoint, or is presumed to have reasonably believed, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself against Pablo Rodriguez Salazar's use or attempted use of unlawful deadly force, and 3, Mariano D. Rendon's use of deadly force was not in response to verbal provocation alone, then you will find in favor of the defendant on his claim of self-defense and acquit the defendant, Mariano D. Rendon, and say by your verdict not guilty. However, if you find from the evidence beyond a reasonable doubt that the defendant, Mariano D. Rendon, committed the offense of aggravated assault, and you further find from the evidence beyond a reasonable doubt that 1, Mariano D. Rendon did not reasonably believe, as viewed from his standpoint, and is not presumed to have reason to believe, that Pablo Rodriguez Salazar was using or attempting to use unlawful deadly force against Mariano D. Rendon, or 2, Mariano D. Rendon did not reasonably believe, as viewed from his standpoint, and is not presumed to have reasonably believed, that the use of deadly force and degree of deadly force used was immediately necessary to protect himself against Pablo Rodriguez Salazar's use or attempted use of unlawful deadly force, or 3, Mariano D. Rendon's use of deadly force was in response to verbal provocation alone, then you will find against the defendant on his plea of self-defense, but next consider whether the defendant acted in defense of a third person as instructed below. Defense of a third person application. Keeping in mind these instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Mariano D. Rendon, committed the offense of aggravated assault as charged in the indictment, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 1, Mariano D. Rendon reasonably believed, as viewed from his standpoint, or is presumed to have reason to believe, that Pablo Rodriguez Salazar was using or attempting to use unlawful deadly force against Anthony James Cochran, and 2, Mariano D. Rendon reasonably believed, as viewed from his standpoint, or is presumed to have reason to believe, that his use of deadly force and the degree of deadly force used were immediately necessary to protect Anthony James Cochran against Pablo Rodriguez Salazar's use or attempted use of unlawful deadly force, and 3, Mariano D. Rendon reasonably believed, as viewed from his standpoint, or is presumed to have reason to believe, that his intervention was immediately necessary to protect Anthony James Cochran, and 4, Mariano D. Rendon's use of deadly force was not in response to verbal provocation alone, then you will find that the defendant, Mariano D. Rendon, acted in defense of a third person and acquit the defendant and say by your verdict not guilty. However, if you find from the evidence beyond a reasonable doubt that the defendant, Mariano D. Rendon, committed the offense of aggravated assault as charged in the indictment, and you further find from the evidence beyond a reasonable doubt that 1, Mariano D. Rendon did not reasonably believe, as viewed from his standpoint, as is not presumed to have reason to believe, that Pablo Rodriguez Salazar was using or attempting to use unlawful deadly force against Anthony James Cochran, or 2, Mariano D. Rendon did not reasonably believe, as viewed from his standpoint, and is not presumed to have reason to believe, that his use of deadly force and the degree of deadly force used were immediately necessary to protect Anthony James Cochran against Pablo Rodriguez Salazar's use or attempted use of unlawful deadly force, or 3, Mariano D. Rendon did not reasonably believe, as viewed from his standpoint, that his intervention was immediately necessary to protect Anthony James Cochran, or 4, Mariano D. Rendon's use of deadly force was in response to verbal provocation alone, then you will find against the defendant, Mariano D. Rendon, on his plea of defense of third person and find him guilty of the offense of aggravated assault as charged in the indictment. As you were instructed during trial to ensure that the jury, the court, and the parties are all receiving the same testimony, whenever a party or witness does not speak English, the services of an interpreter are employed. You are instructed that you, as the jury, are to base your deliberations on the questions as they came from the attorneys in the English language and in the responses from the witness as they came from the interpreter in the English language. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to reach a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching a unanimous verdict, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty, nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable forms are attached. State, are you ready to proceed?
Yes, Your Honor.
All right, you may proceed.
Whatever it takes. This is the defendant's philosophy of how he runs Volcan and what he will do to somebody if he perceives them to be doing something that he doesn't agree with in his club. Ladies and gentlemen, you've heard all the evidence in this case, and I'm going to talk to you about the elements of the offense. These elements have essentially been stipulated to by the defense, and really what we're going to be talking about is the justification and whether the defendant was justified in his actions or not. I submit to you that he was not. But regarding the elements of the offense, we have the offense date on or about August 20th of 2023. You heard multiple witnesses come in and say and testify to this date. You saw Officer Salas. He testified that he showed up to Volcan on that day. You heard from the witnesses who said that they were there at the club on that day. In Bexar County, you heard from multiple witnesses that this assault occurred at Volcan, which is located here in Bexar County on Ingram Road. Regarding the assault, intentionally, knowingly, or recklessly. And so you have the mental states and the definitions and the jury charge, and we'll talk about that further later. And then causing serious bodily injury to another. You all heard from Pablo Rodriguez Salazar. He took the stand and he testified about the injuries that he sustained, about the extensive hospital stint that he had to undergo. And you all also heard from Dr. Gunst, who testified to the serious bodily injury in this case. And at the conclusion of this case, we will be asking you to find the defendant guilty as charged of aggravated assault causing serious bodily injury. And we reserve the rest of the time.
All right, defense.
Ladies and gentlemen, jury, first of all, I want to just thank you for your time and attention to this case. It's important to the state. It's definitely important to Mr. Rendon. You know, this is a terrible situation, and I'm sad that Pablo Rodriguez was injured in this incident, and Mariano is too. Unfortunately, Pablo Rodriguez and the people with him caused a dangerous situation to occur in El Volcan that night. They assaulted Anthony Cochran. They began this melee, which got out of control. Mr. Cochran is injured. You've seen the photographs of Mr. Cochran. This horrible thing happened because Pablo Rodriguez and the people with him drank too much and were angry and combative. I lost my clicker, forgot it, so this is my clicker, he's not doing a very good job. Okay, so we talk about it. So this case is really about a couple different things. It is about self-defense, it is about defense of a third person. And what's understanding, and understand what we're here to do today is basically, this occurs in just seconds. The assault occurs, and you heard from both Chris the porter, you also heard from Mariano, that in just seconds, this, Anthony Cochran's asking for the beer. This tug of war comes in between the beer. Pablo Rodriguez grabs Anthony Cochran. They end up struggling. They end up going to the ground multiple times. And then all these people pile in. You heard Mariano's testimony, and you heard Chris saying, hey, I was trying to keep these people away. I'm 135 pounds. There's 3 or 4 of them. They're all on top of Anthony. There's nothing I could do. He was trying to help his friend. He just wasn't physically not able to because of the number of people that were involved. Mariano said when he gets over there, he starts pulling people off the pile. He's literally pulling off the pile. And he's very concerned and scared for Anthony because Anthony's in this pile of people. Mariano told you that they were punching him. They had already removed his baton. They'd already removed his radio. And now what's to stop them from removing that firearm? And he talked to you about how he saw that as danger. And you're going to see in the charge, there's the thing about apparent danger. That firearm is apparent danger. The fact that they are fighting with him and removing his uniform, and there is a weapon in that pile, that is a dangerous situation. And it's a situation that had that gone and had he gotten that firearm, horrible things could have happened. And because of that, and because of the totality of the circumstances, Mr. Rendon had to step in and defend Anthony Cochran. And he had to do that, and he had the reason to do that. But basically what the law says is that if Mr. Rendon was in Anthony Cochran's position and receiving that assault, could he defend himself? If the answer is yes, and if he has to, he would be justified under 9.32 is the statute to using deadly force to protect himself. So if he was sitting in Anthony Cochran's position, could he use deadly force to protect himself? If the actor reasonably believes his intervention is immediately necessary to protect the person. And obviously in this situation, he felt it was immediately necessary. Why? Because when he gets up there, Anthony's surrounded by these people. They're punching him. They're on top of him. They're taking off his items, and he's got his firearm there. So it's clearly immediately necessary for him to step in and do something. And if you watch the video, and we'll talk about the video being edited a little bit later, in that video, you see, as you watch it, you see Pablo Rodriguez fighting to get back to his stomach so he can get back up. And so this is clearly a dangerous situation. And Anthony Cochran has his hands and is holding Pablo Rodriguez, but Pablo Rodriguez is holding him as well. So it's obviously reasonably necessary. We talk a little bit about it. We kind of talked about this. Pablo Rodriguez is doing 2 things during this assault. Okay, one, he's creating this incredibly dangerous situation where he's physically assaulting him, causing him, Anthony Cochran, bodily injury, but he's also causing, and again, when we have multiple attackers, like in this case, where we have multiple people attacking him, that danger level goes way up. And then also we have the danger, and then there's also this robbery that's occurring. And you heard Chris, the porter, talking about how he saw Pablo Rodriguez tugging on the radio of Anthony Cochran and stripped it off of him. And we know that eventually it's stolen and transported to another location. And that is a robbery, literally a robbery. It is a theft from person using violence, and that is a robbery. And there's a deadly force when we talk about look, I don't think it was Mariano Rendon's intention to use deadly force. I think he was trying to do what he felt that he needed to do to stop this man from fighting, possibly getting to his feet or getting the gun of Anthony Cochran. Okay, I don't think in his mind he's thinking I'm going to use deadly force. But deadly force, understand, is it's a result of the offense thing. So, for example, if I punch somebody, that's not normally deadly force. But if I punch somebody and they're next to a stairway and they take a bad step and they fall down the stairway and they receive serious bodily injury, then that is deadly force, even though it's the actual intent is just to throw a punch. It's more of like the consequence of what happened. And that's why we're talking about that, is just because there's this allegation of serious bodily injury. So if the court, when we talk about this presumption, so there's a presumption in the law that says that if you believe that a couple things happen, if you believe, first of all, that Mariano Rendon did not create the difficulty and provoke the difficulty, that he did not, absolutely. Pablo Rodriguez created the difficulty. Mariano Rendon was just responding to it. Second, that he's not doing any kind of crime other than like a traffic offense. And the reason they have that is because they don't want drug dealers basically saying, oh, he came to rob me for my drugs and I'm now defending myself. No, and at this time, what is Mariano Rendon doing? He's in his bar doing the bottle collection. He's not violating the law. And then third, that he is aware that they're and trying to prevent a theft, or I mean a robbery. And a robbery is that violent taking of the radio by person, and obviously he is doing that. So the state would have to disprove beyond a reasonable doubt that that did not occur, and they're not able to do that because we know that that occurred from the testimony that occurred. So what do we have? So we have this presumption, and that means that you have to find, if you believe those three things, if you believe that Mariano Rendon was aware of the theft that was occurring and trying to prevent it, or the robbery that occurred and was trying to prevent it, and you believe he was not provoking the dispute and he was not committing any crime when he did that, then he is you have to presume that his use of, in this case, deadly force was reasonable and necessary. You have to presume that. You were required to find that if you find those three things. And I would tell you that you have to find those three things because that's what the evidence in this case indicates. So, and this is the robbery presumption that we've been talking about. And you see, in this case, it's that you have to find that because of those three elements. So, look, when you read the deadly force provision, it talks about three different things. One is, did the person intend or know that what they were doing would cause serious bodily injury? And I would tell you, no, I don't think he knew that. I think that he felt that that was the easiest way for him to get to comply. I think that he felt that the knee strike to the abdomen was reasonable and necessary to, one, stop Pablo Rodriguez's continuing fighting with Anthony Cochran, was reasonable and necessary to prevent Pablo Rodriguez to get the firearm of Anthony Cochran during that struggle. I think he felt that was reasonable. And I think that he felt that that was going to cause, some kind of pain and also maybe disrupt him enough that Anthony Cochran could get a hold of him. I think also one of the things to remember is that this happens in just seconds. And remember the chaos of this scene that happens. Remember when we watched the video and I pointed out there's a guy in the back of the video that's on the ground who was probably one of the people that was attacking Anthony Cochran. And there's a security or some kind of staff member between him and there. You can kind of see if you go watch the video and if you pause it, you'll see him sitting there or either on his butt or on his knees. That person is still a threat to Mariano Rendon. We also have Esperanza, who is running around pulling at him and scratching his neck and assaulting him. And that gives him concern for his own safety because he's in a situation where he has Pablo Rodriguez, these other three guys that are attacking, and Esperanza, all attacking Anthony, but also attacking him. And he has injuries that indicates that. That's why it's not just defense of a third party, it's also self-defense, because in the totality of the circumstances, he is also under attack. As well as the young man that got his shoulder dislocated. This is a melee, and everyone is in danger while this melee is going on. We see people all the time, Muay Thai fighters using knee strikes to the abdomen. We see this in all kinds of martial arts, and 99% of the time, nothing happens. 99% of the time, there may be some thing, but we don't have serious bodily injury. We see police officers do this all the time. I'm sure if you've watched Cops or any of those shows, you've seen police officers use knee strikes on the abdomen of people. They wouldn't do that if it was going to routinely cause serious bodily injury, okay? But like we talked about with the punch, I could throw a punch at somebody, not intending to cause death or serious bodily injury, but I could throw that punch at them and they could fall down and hit their head on this table, or they could fall down a flight of stairs, or all kinds of things can happen that transforms it from just like force to deadly force. Okay. But the question for you is, when you're looking at the reasonableness, because I think you do have to look at the reasonableness of what he did. Was the knee strike reasonable? Another thing, when you watch that video, take a look at it. Right before he actually drops his knee, you'll see him crouch down a little bit. So he's not dropping from his full height. He actually crouches down a little bit before he goes down. And I think that's important. But again, seeing police officers, seeing Muay Thai fighters, seeing all these people, just like you all have, do these kind of things without having that kind of a result. Let's talk about the injury. You know, I think there's a real legitimate issue in this case about the injury. Was it caused by the knee strike? And again, if you find it was not, then there's no serious bodily injury, then Mr. Rendon is not guilty. And so you'll remember when I was talking with the doctor and we were talking about all these different things that can cause a ruptured intestine. We talked about, you know, an infection that causes inflammation or diverticulitis. We talked about peptic ulcers. We talked about blunt force trauma is one of the things that can do it. Penetrating trauma, like a stab wound, is something that could do it. Inflammatory bowel, appendicitis. There's just long-term NSAIDs, bowel obstruction, and one of them is scarring from surgery. And we know from the medical testimony that Pablo Rodriguez had a previous hernia operation. You heard the doctor talk about that, and he talked about how sometimes there can be scar tissue inside the bowel that can, over time, cause a bowel obstruction. So one of the things you need to do is you need to sit down and take a look at that and decide if this knee strike actually did cause that serious bodily injury. You know, one of the things is there's a delay in reporting. Is you saw him walk out of the bar, you know that he went home, and these problems developed later. Is it because they did not occur from the knee strike, or is it because there was just a delayed outset? So you need to sit down and take a look at it. And again, I think that fact that he had this previous hernia surgery and that scarring from a surgery is something that can cause a bowel obstruction, I think is important. We also look at this, is if it's possible that the knee strike caused it, that's not proof beyond a reasonable doubt. The state's burden is very high. We talked about it. They have to prove beyond a reasonable doubt that the knee strike caused that injury. Most likely is not beyond a reasonable doubt. You have to believe beyond a reasonable doubt that the knee strike is what caused the injury. One of the problems with the state's case is we have unreliable witnesses that are basically telling you lies. This is one of the most significant pictures in this case, not because it goes to any element of the offense, but because you heard the testimony of Tina Jimenez and Pablo Rodriguez, that he just walked out of his own accord, that he just got up and walked out. But here we see him being escorted out by Anthony Cochran. Okay. Was it that he was so intoxicated that he doesn't remember being escorted out? In which case he probably lied to you about the number of drinks that he had. Or is it that he's purposely trying to make himself look good and reasonable and in a sense lying to you? Because we know that he got walked out. So it's like somebody brings something and then we bring the receipts. And that's the receipt of that. This tells you that when he told you that and when she told you that was not true.
5 minutes.
Next slide. The same thing with the drinking. We have the same issue. So first of all, let's talk about court and police math when it comes to drinking. Every person that's ever been convicted of DWI, 90% of them told you they had 2 beers and that you can't get to 0.08 on 2 beers.
All right, that'll be overruled.
So every person says they had 2 beers. In this case, he told you he had 5. And so the actual, this is just my joke equation, but it's kind of accurate. Is you take the number of actual drinks you had, you divide that by 3, and that's what you tell the police officer. So I had 6 drinks. I tell the police officer I had 2. If I had 5 drinks, I divide that by 3, and I tell them that it's actually 15, but I tell them it's 5. But the bottom line is you're saying something to sound better than the truth, which is a lie. We talk about all the things, Tina and Pablo both made it seem like he barely had anything to drink. But then when we bring the receipts, we see Officer Casey Wilson said that when he saw them, that they were highly intoxicated and combative. And Pablo, her own statement, she once she heard the tape, because we brought the receipts, she admitted he drank and drank and drank for his birthday. He was a little more drunk than normal. He had too much to drink. But the bottom line is she only admitted to those facts when she knew we had it on tape. That is somebody who's lying to you. That's somebody who's telling you something that's not true. And the video, let's talk about the video real quick. Why is this an edited video? Obviously, we know that the encounter lasted a long time before this occurred. When you see something like this and you start to turn your video on, you hit the play button and you're bringing it up and it's blurry at the beginning because it takes you a second to get oriented when you're not expected to this. I don't believe Esperanza 1 minute that she got this from the internet. Somebody she knew in the bar took this video and gave it to her. And they took the part that was bad for them and they cut it out. And that's why we only see the last few minutes of this fight. The problem is once you have people that are lying to you, you don't know when their lies stop. You don't know when they're not telling you. Once they start telling you lies, you don't know where that stops. And you heard one party that's being honest and truthful in this. But we have 2 different versions of this event, 2 totally different versions. You have the version of them. He took 1 extra drink and he threw it in the trash can. And Anthony Cochran, who is sober, just goes berserk and attacks him. Is that reasonable? That's not reasonable. He's a security guard. He just wants to get the beer in the bucket so that he can go home in an hour or less than an hour, in about 45 minutes. This is going to keep him there a lot longer than that. It's not reasonable. What's more reasonable is a drunk person who paid for a beer who doesn't want to give it up and is willing to fight for it, feels insulted. When we talk about that, we talk about the 2 different versions, totally different versions. We have one group of people that have told you things that we know are lies and have misrepresented things to you, and we have another party that has not. So you have to choose to believe. And I would tell you that this man and Chris the Porter never lied to you. But when they brought their stuff up and we brought the receipts, they failed. This was a terrible police investigation. And that's important because it's hard for you to get the right facts. How long, we talked about it, it takes 3 seconds to identify these witnesses. What's your name? What's your address? Failed to do it. This is a felony case. This man might go to prison for 20 years and they can't take 2 seconds to take the names and addresses of these witnesses and identify them. Witness statements. Every single person that saw that fight should be getting a witness statement, even if it's only a few minutes on the body cam. There's people that never spoke to the police. They didn't even identify them. And what were they doing? They were lying about their names. You heard Esperanza say that she's an admitted liar. She said I gave him a fake name. We have the other guy. His name in the report is completely different than what his real name is. They failed to go look at the videos. They're right there. The only reason they have the videos from inside the club is because we provided it to them. They never asked Tina and Pablo who else was there. Why wouldn't you do that? Hey, you've come to us. You want us to investigate this? Then we're going to sit down. Who was this other person? Let's go get a witness statement from him. They never talked to any of them about the assault. They never confronted. If you're taking a witness statement from somebody, you take what they got to say, but then you take what the other people say and say, hey, wait, they're saying that you assaulted somebody. Let's ask about that. They never did that. It was a biased, not only was it a terrible investigation, it was a biased investigation. There were crimes that they knew about. They knew about the robbery. They knew about the assault, and they never looked into it. They never confronted those people with that. They never confronted Esperanza about her conduct on the video. Look, if she really got the video from some strange person, the state can file a subpoena, get those social media records, find out when that video was transferred and who transferred it for them, and go see if they have the original video that's unedited.
Time.
Failed to do that. Just 1 second, Your Honor.
Okay.
Next slide. Look, they have to prove this case beyond a reasonable doubt. And they have failed to do so because they have failed to disprove that he was not acting in defense of himself, not acting in self-defense of Pablo Rodriguez. And because they did the robbery, you're presumed to find that that is accurate. Thank you very much for your time.
I don't care how bad Pablo is, he's a civilian. Ladies and gentlemen, that is unreasonable. And it is not supported by the law, and that is the reason that we are here today. Now, I've already talked to you about the elements of the offense. I'm going to talk to you about the mental state. You are not required to read minds. You can infer this from the facts and circumstances that surround this. You heard testimony from the defendant that he did not bluntly strike Pablo with his knee because he intended to be cruel. But his acts, by definition, were reckless. And we're going to look at the facts and circumstances that surround this and prove that it was reckless. The defendant's desire was to strike Pablo with blunt force with his knee. If you look at State's Exhibit number 2, when Pablo is struck, he is laying, his head to his tailbone is laying flat on that wood dance floor. His left side of his stomach is fully exposed, and the defendant grabs Pablo's left knee and grabs onto Anthony Cochran's back and drops his knee down. We all know that the stomach is a sensitive area that is full of many vital organs, and any blunt force to an area like that that's unprotected can cause a tear, rupture, or fracture of any bodily organ. Now, I want to talk to you all about the defenses. The defendant was not acting in self-defense at all, okay, especially against Pablo. There's been no evidence that he perceived any threat coming from Pablo. What he testified to is that he believed that Esperanza was using force against him and that he used force back against her. But regarding Pablo, you all see the video. The video is the clearest piece of evidence that we have in this case. And Pablo is not threatening the defendant. Now I want to talk to you all about defense of third person. Regarding the defenses that are in the jury charge, just because you receive them in the charge does not mean that it's the court commenting on whether these are legitimate defenses or not. Okay, the defendant is entitled to it because it was raised by the evidence. And so let's talk about defense of a third person. A defendant is justified only when he reasonably believed, as viewed from his standpoint, that Pablo was using or attempting to use unlawful deadly force against Anthony Cochran, that his intervention was immediately necessary to protect Anthony Cochran, and that his use of deadly force and the degree of deadly force were immediately necessary to protect Anthony Cochran. Well, let's look at the evidence. It is clear that Pablo Rodriguez Salazar was not using or attempting to use any unlawful deadly force against Anthony Cochran. And how do we know that? Well, the witnesses all testified that Pablo didn't use any force at all. When you look at the State's Exhibit number 2, when Pablo's laying on the ground, you can see that he's kicking his feet around a little to free himself from the grip of Anthony Cochran. That is not deadly force. That, at a minimum, would be non-deadly force. And so you cannot respond to that with deadly force. The defense witnesses testified to a tug of war over beer. Okay, that is non-deadly force. You cannot respond against unlawful, you can respond against unlawful force with regular force. You cannot respond against unlawful force with deadly force, which is sending somebody to the hospital for 50 days. The defendant's intervention was not immediately necessary. And how do we know this? In the State's Exhibit number 2, Anthony Cochran is on top of Pablo the entire time. Pablo, at a minimum, is shifting his weight from side to side. As I explained earlier, Pablo's head to his tailbone is laying flat, stomach fully exposed, and that's when the defendant grabs onto Anthony's back and Pablo's leg and drops his knee down. So he knew at that time, in his standpoint, he knew that Anthony Cochran was on top of Pablo, and he knew that Anthony Cochran had control of Pablo at that time. That's what makes his acts unreasonable. His use of deadly force and the degree was unnecessary. The defendant testified that his own staff is not allowed to go hands-on with patrons. That's a rule that he implemented. that he implemented and he violated himself. You heard his testimony. He's not a peace officer. He's not a security guard. So if he has this rule in place for his staff, why is he violating his own rule? He testified, the defendant testified from that stand that the proper next step would have been to go and grab Pablo's legs and neutralize any movement. Okay, that is not what he did. A reasonable belief is a belief that is held by an ordinary and prudent person in the same circumstances. So let's look at that. Let's look at all the other patrons that are in the vicinity of what is going on. They're all standing watching there, including Chris Villanueva, who I would implore was not a credible witness at all. He wouldn't even admit that he was in the state's exhibit number 2 and a photo of him clearly in the entrance exitway of Volcan. You cannot believe anything that he said. You can see that other people, other patrons are walking by. Some people are still dancing. And some people in the crowd are yelling at the defendant. And look at the defendant's demeanor in state's exhibit number 2. He's yelling at people in the crowd that are not even involved. There was no apparent danger, and that is clear because there is no sense of urgency from anyone else in the location but the defendant that's sitting over there. The defendant is the only person who felt that he needed to protect Anthony by assaulting Pablo. If Anthony had a firearm, why does he need to be protected? That was an unreasonable belief. There's no presumption of reasonableness in this case because there's no evidence of a committed robbery. Ladies and gentlemen, you will have the evidence with you, which includes video of Esperanza, Carlos, and Ricardo exiting the location. You don't see the hat, you don't see the baton, and you don't see the radio anywhere. The defense also, the photo that he had with Pablo walking out, you don't see the radio, baton, or hat anywhere. Volcan was packed that night. Anybody could have taken those items. There is no proof that Pablo, Tina, Esperanza, Carlos, or Ricardo took any of those items. And so there was not a robbery on that day. Furthermore, at the time that this occurred, the defendant had no knowledge that these items were missing. He comes in when he says that this whole, using their words, melee is going on. He has no idea that those things are even missing if they were, and they are depicted in the state's exhibit number 2 laying on the ground. But you all need to track the exit of the witnesses, and you can see that they are not in possession of any of those items. You can also look on the officer's body-worn camera. When they're speaking to the officer, they are not in possession of any of those items. And so we have proved beyond a reasonable doubt that no robbery occurred. The evidence supports a finding against the defendant's assertion of self-defense and defense of a third person. Testimony is evidence. We talked about this in jury selection, so we're going to talk about some of the testimony that you heard. You heard from Officer Salas. He testified that he was first on scene at Volcan on August 20th, 2023. He testified that Pablo did make an outcry to him on that night regarding the assault, but he did not make any arrest on that night. When he had an opportunity to view state's exhibit number 2, he testified that he would have reached a different conclusion had he been in possession of that video on the night. We'll move on to Officer Soto. He testified that he was dispatched to Pablo's home 2 days later on the 22nd to take a report. He took statements from Pablo and Tina. He researched the negligent investigation that Officer Salas did. And knowing that information, he still decided to write up a report and forward it to a follow-up unit for investigation to occur because he determined that an offense had occurred. Detective Gross testified that he conducted many interviews. He collected the video evidence, which corroborated what the witnesses testified to, Pablo, Esperanza, Tina, and Carlos. And the result of his investigation was the use of force was unreasonable. He also conducted an interview with the defendant, who stated that he didn't even touch Pablo at all, and that the internet was down for the cameras, so he was unsure if he would be able to provide the surveillance video. Ladies and gentlemen, if the defendant was in such fear and he felt that his acts were reasonable, why would he say that he didn't touch Pablo at all? Because he knows that his use of deadly force exceeded the scope of the law. Of important note, he fails to mention things that he testified to on the stand, which was that Pablo jolted his head. The first time that we heard of that was last week. That he was in fear for Anthony's life. He's never stated that until last week. That Pablo was reaching for a gun. That has never been uttered until last week when he was on that stand. And that Pablo was cut off from receiving any more alcohol. Never mentioned that to Detective Gross. I want to agree with one thing that the defendant said, is that it's easy to Monday morning quarterback when you know that you're facing the jury of your peers and you've had 2 years to concoct a version that is sympathetic to yourself. The only thing that the defendant told Detective Gross is regarding Esperanza. And he said that Esperanza attacked him and that he used force against her. Okay. What is important is that nobody had State's Exhibit number 2 at this point. And so the only reason that he's coming up in here and taking accountability is because we have State's Exhibit number 2. If there wasn't a patron that was recording that night, we would have never known who caused serious bodily injury to Pablo. Tina would have never known that this person that she trusted caused serious bodily injury to her husband. You all heard from Dr. Guns. He testified that Pablo sustained serious bodily injury. You heard that Pablo had to have 2 surgeries. The first was removal of a part of his intestine, and the second was the bowel obstruction that was caused by the first surgery. Okay, not some hernia surgery that happened 9 years ago. And so I want you all to think, is it possible that the hernia surgery is what caused the intestine issue? Maybe, but what does the evidence suggest? Look at the location of the blunt force strike and the temporal location. 2 days later is when he has to go to the hospital. It's unreasonable to believe that he lived with the hernia surgery 9 years, and then just shortly after this is when he's gonna have issues from a hernia surgery. That's unreasonable. Pablo, Tina, Esperanza, and Carlos are all consistent with each other and the video evidence. At this time, you are solely determining whether the defendant is guilty or not guilty. Not defenses to this offense, or that the defendant did provide some video that's hazy and we can't even see what's going on, that Pablo was cut off if he was intoxicated, that it was last call, and that Pablo didn't throw his beer away. I want you all to think, what was the rush? The defendant testified that his patrons can continue drinking until 2:15. What was the rush that Pablo had to throw his beer away right then and there? That it would cause Anthony Cochran to grab the beer from Pablo
5
and
minutes.
throw him to the ground. We do have the burden beyond a reasonable doubt. It is not beyond all doubt, but ladies and gentlemen, that video tells you everything that you need to know. You are not to let bias, prejudice, or sympathy play into any part of your deliberations, and you all do have a duty to deliberate, to consult with each other, and with a view towards reaching a unanimous verdict. And you shouldn't hesitate to re-examine your views and change your opinion if they are unreasonable. You all swore to render a true verdict according to the law and the evidence. Ladies and gentlemen, there is only one verdict in this case, and that is finding the defendant guilty of aggravated assault causing serious bodily injury. We cannot hold a substandard law enforcement investigation against Pablo, okay? Tina had to fight for Pablo to receive an investigation that would bring us here today. You need to hear them, let them know that you hear them, that you believe them, and find him guilty.
All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict. Is that correct? And is that verdict unanimous? All right, if you'll hand the jury charge to Deputy Laura, please. All right, is the defendant, if you'll rise, please. It states, we, the jury, find the defendant, Mariano D. Rendon, guilty of the offense of aggravated assault as charged in the indictment. You may be seated. Does anyone wish to have the jurors polled?
Yes, Your Honor.
All right, ladies and gentlemen, with the exception of the alternates, and I know who the alternates are, I'm going to ask you if this is your verdict. If this is your verdict, I want you to answer yes. Does everyone understand? And we'll start on the front row. Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? And we'll start on the back row on the end. Is this your verdict? Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? All right, ladies and gentlemen, what I'm going to do now is I'm going to have you all go back to the jury room. There are a couple of things that I'll need to discuss with both parties before we proceed to the second phase of this trial. Everyone, please rise for the jurors. All right, so this is, I'm trying to find out from both of you all, how do you want to proceed? If you would like to proceed, I don't know if parties have their witnesses here already for this second phase of the trial. If you do not, if you all want, we can continue tomorrow.
I would prefer to keep tomorrow, Your Honor. I think it's kind of late in the day to get started on that. And I would prefer to start in the morning, so I think we can knock it all out tomorrow.
All right, so how many witnesses do you all anticipate for each side? Okay,
I would have 2 to 4, Your Honor.
all right, so Ms. Ferguson, this is what we'll do. On this case, we'll start at 9 a.m. And Norma, if you can move our morning docket to the afternoon.